I'm Shanna Welsh-Levin with Southern California Realty Law. We protect real estate investors and real estate professionals. I have been an attorney for over 18 years now, going on 19, in San Diego. I've only practiced real estate law in my career, and I have been representing landlords since 2006. I did my first eviction in 2006. In 2020, we started doing these webinars, and so we're always up to date on the latest information for landlords. At this time, the firm only represents landlords with very, very few exceptions. We also represent commercial tenants, and we provide comprehensive landlord services, which includes eviction litigation, but also we do leases and a variety of other things for landlords. In addition to the landlord services, we do a variety of litigation, both plaintiff and defense litigation for real estate fraud cases, easement and boundary line disputes, HOA issues, and then we do some transactional work as well. Again, mostly residential on that side. We don't do any kind of property development or land use. We leave that to those specialists. We don't do construction defect. So that should give you some idea of who we are. And we have a team of 8. So we've got 3 attorneys on staff and 2 paralegals, and then some administrative assistants who help us with things like intake and case management. And that's how we keep everything running efficiently and timely for our clients. What we really strive to do for landlords is to prevent getting stuck in the eviction process. And if you are stuck in the eviction process, we try to move things forward efficiently as quickly as possible, always subject to the court's timelines. But the goal is to work with tenants if possible and to try to reduce litigation. One of the main things we do to try to reduce litigation is keeping landlords informed using these webinars and our newsletters so that you know what to watch out for and when you might need to come in and get some legal advice. So thank you all very much for coming today. I've got a lovely PowerPoint for you as usual. Let's get that started. All right, so today is a California legislation update, and we'll talk a little bit about the battle over rent control. But as promised in the updated invitation, we will also open the floor for Q&A because I think I've only got 20 minutes to a half hour of material for you. And one of the good news is that there actually isn't that much legislation relating to landlords that's going through to become new law in 2024. I guess they feel like they've beaten up the landlords enough already, and maybe they'll leave us alone for a little bit. Here's hoping. So California rent control is a very interesting topic, and we're seeing a lot more red flags from legislation that is seeking to repeal what's currently protecting landlords from certain kinds of rent control, but there's also a ton of rent control that's already out there. There's a lot of debate about whether rent control actually benefits the population that it seeks to help. So we think that it seeks to benefit people with lower income who would otherwise not be able to rent or buy in certain cities or high density areas. But it seems to prevent landlords, well, it also seeks to prevent landlords from hiking up the rent when the demand for housing increases. We all know there's a huge demand for housing in California, not enough housing out there. So it prevents landlords from hiking up the rent on existing tenants. What it tends to do is benefit people who have stable income, who stay in one place, who retain rent-controlled units for long term. And it negatively impacts a lot of landlords who hold those older units, mostly units that were built prior to 1995. Arguably, it also prevents landlords from having the resources to perform adequate maintenance on older units that are subject to rent control. You'll find that there isn't a lot of rent control in the county of San Diego or in the cities around San Diego, so we don't experience it in San Diego very often, but there are lots of other places that have it. And it tends to chase renters into areas that have newer housing where more units are available. and it exacerbates the housing crisis for much of the vulnerable population. That's what studies have shown. I'm not placing any of my own opinions on there. This is just information. My resources are California Apartment Association, California Association of Realtors, my own research on Westlaw, whatever I can gather myself through the news and the internet. So our current rental law protects, our current statewide law protects landlords, and we have the Costa-Hawkins Act and the Ellis Act. And believe it or not, they are landlord protection laws. The current state of the law allows for local price controls on rent. So a city or a county can place certain restrictions against landlords, and this is under their police power. They have to make sure that the law is reasonably calculated to eliminate excessive rents while providing landlords with a just and fair, reasonable return from their property. And the law also has to provide for due process, and it also cannot be arbitrary. The Ellis Act allows a landlord to go out of business. And so those are the high points of what the current landlord protections are. So Costa-Hawkins, as I mentioned, it does not allow rent control on any separately alienable unit that's built after 1995. That's when the law was passed. There are some additional exceptions to the law. I am oversimplifying it by far. But the overriding purpose of Costa-Hawkins Act is to allow landlords to set the initial rent on units that are new construction or on units that become vacant. So Costa-Hawkins mandates vacancy decontrol. What that means is, without Costa-Hawkins, when a property would become vacant, without Costa-Hawkins, local regulations could be put in place to prevent the landlord from increasing the rent beyond a certain controlled amount. Costa-Hawkins says no, local rent controls cannot do that. If a property becomes vacant, the landlord can set the new rent at fair market value. And similar for new construction, it gives the landlord the right to set the rent at fair market value. It's important to be aware that in the event that Costa-Hawkins might be repealed, we're fighting so that it's not repealed, but there are groups that are fighting to repeal it. If it were repealed, there's already an existing law in place that would authorize local rent control on vacant units. And so that would be difficult for a lot of landlords who honestly, they need to wait for units to become vacant in order to increase the rent to a reasonable amount. We have the Ellis Act. The current Ellis Act, the highlight is that the ordinance, or that a local ordinance cannot restrict a landlord's right to remove a unit from the rental market, as long as the landlord's removal of the unit is not inconsistent with the landlord's right to go out of business as defined under the Act. It also can't conflict with other specific provisions of the state law, but ultimately, if a landlord is in foreclosure, that's okay. They're allowed to lose their property to foreclosure. Even though there may be tenants in the property, it's not illegal for a landlord to go through the foreclosure process. And likewise, if a landlord decides to sell a unit because they want to go out of business, they're allowed to do that, and that can be one reason to evict a tenant or to terminate a tenancy. But many local laws are already in place throughout the state. There is a really, really nice table listing all of the local regulations throughout the state, and it's published by the California Apartment Association. I need to see if I can distribute this as one of our freebies with the webinar. I always like to send you some freebies. but I have it as part of my PowerPoint. I just need to confirm whether the California Apartment Association authorizes me to distribute this. It's really helpful. So it goes by city and county. The city that has the rent control ordinance, some basic details of what the rent control cap is, how the rent increase cap is calculated, when the ordinance was adopted, the date it expires. And you'll see that the construction date exemption for the most part is either 1995, things that, the exemption kicks in for things built after a certain date in 1995. February 1st is, I assume, the date that Costa-Hawkins went into effect. Some of them are earlier. It lists some of the exemptions and sends you right to the city or county website that describes the local ordinance. So this is a very valuable piece of information. You can see City of Alameda, City of Antioch, Baldwin Park, Bell Gardens, Berkeley, Beverly Hills, Culver City, East Palo Alto, Fairfax, Gardena, Hayward, Inglewood, Larkspur, City of Los Angeles, unincorporated Los Angeles County, Los Gatos, Mountain View, Oakland, Oxnard, Palm Springs, Pasadena, Pomona, Richmond, Sacramento, San Francisco, San Jose, Santa Ana, Santa Monica, Thousand Oaks, and West Hollywood. Notice up here, it states not including stopgap pre-AB 1482 measures. So I don't recall those stopgap pre-AB 1482 measures, but you might have the question in mind, how is AB 1482's rent cap different from these local regulations? In particular, AB 1482 is a state law. It was created to be consistent with Costa-Hawkins and the Ellis Act. It doesn't change Costa-Hawkins or the Ellis Act, but it does add the statewide cap. So the state could do this if it chose to, and that is why we're watching that legislation. But in order to be consistent with Costa-Hawkins and the Ellis Act, basically you would have to, it's my understanding that you would have to repeal Costa-Hawkins in order for a different kind of statewide law to go into place. The AB 1482, our rent cap just cause law, has a time frame that is a rolling 15 years. So the automatic exemption from AB 1482 is properties are automatically exempt if they are less than 15 years old. So as properties age, they become non-exempt under AB 1482. So it's designed differently, and maybe arguably they looked at Costa-Hawkins and designed it in a way that might be more reasonable. Now, there is a proposed law. The good news is that it's not coming through this year, but so the latest rent control proposals that came through this year are not moving forward, but there is one that came through this year that actually is qualified for the November 5th, 2024 ballot, and it is a proposed repeal of the Costa-Hawkins Act. And depending on what we cover in future webinars, I will go over that in a little more detail. I just did not have time to go into it in great detail today. We're watching some other legislation as well. So there is a bill, Assembly Bill 12, that deals with security deposits. So this security deposit bill proposes to cap security deposits at 1 month of rent, and that's regardless of whether the unit is furnished or unfurnished. Right now, a landlord may charge 2 months of rent, the equivalent of 2 months of rent, as a security deposit for an unfurnished unit, and the equivalent of 3 months of rent as security deposit for a furnished unit. And I encourage landlords to charge the maximum amount of security deposit. But the basis for the law is that a lower security deposit would allow more tenants to get into rental units. Well, I guess they're suggesting that it's hard to build up the funds to have 3 months of rent just to move into an unfurnished unit, or 4 months of rent to move into a furnished unit. I can understand that, but I think from a landlord's perspective, we like to have the ability to charge at least 2 months of rent for a security deposit. And I've seen many times when the security deposit does not cover the repairs that need to be made to the condition of the premises. And more often than not, we don't pursue the tenant for a judgment because we assume that the tenant would be judgment proof or doesn't have assets that we can find that would be collectible. Then again, getting a judgment against the tenant, it's good for up to 20 years. And I think that is a good idea to get one if you have the ability to pursue litigation. All right, then the other law that we are watching is the changes to proposed changes to the rent cap and just cause law. So this proposal, SB 567, indicates that it wants to change the Tenant Protection Act of 2019. So change the rent cap just cause law by changing the just cause eviction rules and then imposing penalties against rental property owners who don't follow the law. As we've seen with the new City of San Diego ordinance, it has the City of San Diego put a lot of teeth in its law, such as attorney's fees and punitive damages, treble damages, a private right of action. Meaning a private right of action is when the individual can sue under the law. The California Tenant Protection Act of 2019 doesn't have those things. The teeth in the Tenant Protection Act of 2019 is that it stops you from being able, as a landlord, stops you from being able to evict the tenant. It doesn't give the tenant the right to sue the landlord for violations, except under the guise of a separate action for wrongful eviction. You know, a variety of other laws apply to wrongful eviction, and you can use the violation of the Tenant Protection Act within that, but it doesn't have any specific remedies that are scary to landlords. It doesn't have any teeth to encourage tenants to enforce it other than for their own defense. So adding those things to the rent cap and just cause law would encourage a lot of litigation by tenants. It would encourage a lot of attorneys to take on tenant matters. Right now, we have a short list of tenant protection attorneys that we provide when tenants contact us, and they're few and far between. But if you make these changes to this law, I think we'll find that there are a few more attorneys out there willing to take those cases. So I hope that the California Apartment Association succeeds in lobbying against this one. I know the California Association of Realtors will also be lobbying against these laws. Note that if you saw an earlier version of SB 567, it did have a provision that was trying to adjust the California rent cap down to 5%. And that part of the law has been removed. Meaning that we will maintain that 10% rent cap under the rent cap just cause law, subject to annual adjustments. That 10% might be lower next year, depending on what inflation does. And every year we review that. As of this year, the adjustment was calculated and it remained at 10%. Right, so the last couple of webinars we've done, we did a very detailed deep dive into the City of San Diego's new tenant protection law. I'm not going to go into it with that much detail today because you can watch the replay that we have on YouTube. And if you need us to send it to you because maybe you haven't received that link, we'd be happy to send it to you. You can also go to our YouTube channel, which you can find through our website, and you can review a more detailed review of the City of San Diego tenant protection law. But there are a couple updates that I want to make sure everybody's aware of. Number one, for properties that are not exempt from the law, first of all, you have to figure out if your property is exempt or not exempt. Okay, if you need legal advice to figure that out. I completely understand. We do that very often for clients, and I know sometimes it's hard to know that. So please give us a call if you need help figuring it out. If you're not exempt from the law, meaning that the law does apply to your property, then you are obligated. In fact, you were supposed to do this, what I'm about to tell you, you're supposed to do it by September 23rd. If you haven't done it, just do it right away. But you have to give the tenant a notice of their rights, very specific language that is set forth in the statute. You have to give that notice to the tenant. And then there's a tenant protection guide that's published by the San Diego Housing Commission. You can go to their website and download it, or we will send it out to you as a freebie. We've sent it out with each of the past webinars, and we'll send it out again this time. That tenant protection guide must be given with the notice. There are some new provisions that we would encourage you to include in your lease. One of those is to put in your lease that the landlord may terminate the tenancy if the landlord wants to move in. If you don't have that in your lease, that you will not be able to use that as a just cause for a future termination of tenancy. So you have to put that in there now. And there are a few other provisions that I've created a San Diego addendum. Part of the law requires landlords to post in a portal when they serve a tenant with a notice to terminate the tenancy. That's for non-exempt properties, but that portal does not exist yet. I checked it yesterday morning. San Diego Housing Commission has an active not an MOU, ROA for the development of that portal. And so they're going to let us know when it's ready. So it's not ready yet. You don't have to comply with that part of the law until that portal is ready. And that is going to be on the San Diego Housing Commission website. They have a landlord portal already, but it's not for this purpose. Okay. So then exempt properties just landlords need to give the tenants a notice that the property is exempt from the new law. And if you fail to give that exemption, that's okay. Just give it when you realize that you need to give it. And for those of you who are here today, I assume if you're exempt from the law, you've already given your notice of exemption. As of January 1st, 2024, for any new lease, you have to incorporate the language of the exemption into your lease. So you will no longer be able to simply give a notice of exemption. You have to have an addendum to your lease or have the language incorporated into your lease. I don't know, for those of you who may be realtors out there, I don't know if Zip Forms is going to give you this language in one of their forms. Since it's a local law, I think that you'll have to get something locally. I have that language and I've been giving that out to folks who need it. All right, so just remember to do those things. And I'll open the floor. That's all I've got for you today. I'll open the floor. Oh, I have one more quick thing. State of emergency update. As of our last webinar, there was a state of emergency due to Tropical Storm Hillary, and if there is a declaration of state of emergency, that induces an automatic rent cap for 30 days. So that Tropical Storm Hillary state of emergency was declared on August 19th and has now expired. So I checked it out online and I did not see any state of emergency declarations that are currently active for San Diego, Orange County, Los Angeles, Riverside, San Bernardino, or Imperial County. So as far as I know, we don't have the state of emergency rent cap going on. And oh, by the way, there's a QR code here. If you are enjoying our webinars and you feel like giving us a 5-star Google review, we can definitely use all the help we can get on Google. And I would really appreciate it. Thank you very much. So let me go to the chat and see if we've got any questions. We do have a couple, and then I'll take these 2 questions. And then if you have any questions, feel free to either raise your hand and I'll call on you or put it in the chat. So are there any local rent control ordinances for the city and county of San Diego? And that answer is no. As you saw on that list that I was reading from, we don't have any local rent control regulations. The city of San Diego's tenant protection law did not impose a rent cap, and so it is not a local rent control. So the only one that would apply would be the rent cap and just cause law, the statewide rent cap. Don't mistake rent control for things like Section 8 programs and VASH vouchers and things like that. Those are federally funded rental assistance programs, not rent control. All right, in my opinion, must the notice of exemption be served before an eviction notice, or is serving it afterwards okay? If the property is exempt, I think there is a big ambiguity in the way that the law was written, because it says, you know, it gives a date for when the non-exempt property owners have to give notice and that tenant protection guide. And then it says for exempt properties, you have to incorporate this language into your lease by January 1st. But it doesn't say that exempt property owners have to issue the notice of exemption by a certain date. I think the presumption is if you don't issue the notice of exemption by a certain date, then you are not exempt and you have to give the notice of the tenant's rights and a copy of the tenant protection guide. But I think that my advice to property owners who are exempt, who are late in sending out a notice of exemption, just send it anyway. I also think that there is no harm in sending out the tenant protection guide, even if your property is exempt. And so, you know, I would just say send it anyway. I don't believe that there would be any repercussions. I don't think that tenants would actually be harmed if you're a few days or a few weeks late in sending the notice of exemption. So that's my opinion. There's no legal precedent for my opinion, because none of this has been brought to the courts yet. So as far as I'm concerned, better late than never, and go ahead and serve it afterward, as soon as you can. Oh, and I forgot to make the chat private. I apologize. Let me see if I can do it now. Well, I don't want to mess it up. So just so you guys know, if you post a question, the only people who are going to see your name are the people who are in the webinar. When we do the video, we're going to take out all the names and faces and maintain everyone's privacy. So if a tenant cannot find a rental and they were given the 60-day notice, do they have an option? I'm not sure I understand the question. So if they can't find a place to go after the tenancy is terminated, do they have an option? I'm not sure what kind of option you're talking about. If you want to clarify that in a follow-up, I'd be happy to look back on that question. Are there standard leases created to comply with the city of San Diego? No, at this time I have not seen any updates from the California Association of Realtors or the San Diego Association of Realtors to update their forms for really any local rent control. So I am creating my own addenda. I think if I understand your question correctly, you know, I'm creating my own addenda to comply with the law. I'm making them as simple as possible, just taking the language right out of the statute, or I'm sorry, the ordinance, to help all of our landlords to comply. And for the most part, I'm giving out those forms as freebies with the webinar, all except for my San Diego addendum, because that one is particular that I've, you know, tinkered with myself and added language to. All right, next question. So to clarify, they're trying to repeal Costa-Hawkins, which would allow vacancy decontrol. It would allow vacancy control. So Costa-Hawkins imposes vacancy decontrol, and then repealing it would allow vacancy control by local cities and counties. And someone just told you that you can no longer increase rents 5% from previous rent, even for new tenants after a vacancy. Yeah, I don't believe that's true. Now, under local rent control ordinances, there are some, but Costa-Hawkins prevents them from doing that when it's vacant. So you may be prevented from increasing the rent for an existing tenant, but when a property is vacant, as long as there's no declaration of state of emergency, you can increase the rent. Now, be aware that if you're going to increase the rent more than 10%, even if you are exempt from any kind of rent control or the rent cap just cause law, you have to give 90 days notice for increases more than 10%. And that is for every property across the state. So you can do less than 10%, 30 days, as long as your tenant is on month to month. But for anything more than 10%, you have to give 90 days. Gabe, does that help? And if you have some kind of legal authority that there's some area that has passed a law that has that vacancy control, I'd be interested to know
that actually helps a lot. No, someone was just in my office about an hour ago saying, "Oh, this is the new law," and I said, "Really, is it law?" Because you know, I'm sure you hear it all the time of everyone's concerned about what they're trying to pass, but it doesn't end up getting passed. And so I always kind of get flustered and say, "Okay, well, I got to check this out." Is this real or is it not real? And so he was saying that if it's going to become vacant, you now can only increase it no more than 5% above your previous rent.
That's what they're trying to so what this person may have heard is that this proposal to withdraw Costa-Hawkins has now made it to the ballot. So there is
you'll be allowed to do that afterwards if they want to have new rent control, right?
Yeah, then the local jurisdictions could come in and do the vacancy control, but the law that's on the ballot doesn't actually do that yet. It just may create the opportunity.
Got it. Totally understood. Thank you. That was very good clarification.
Okay, good. Well, you get a copy of the PowerPoint. Now, the issue with the PowerPoint is that I'm not sure that I can distribute that California Apartment Association table. If you're a member of California Apartment Association, it's available on their website and it is copywritten. So I will call them and see if I can provide that to you as a freebie. I just didn't have a chance to call up there and see if I'm allowed to do that. Not selling it or anything. So hopefully I will be able to. So if you purchase a property that has existing tenants that had a fixed term lease from years ago, but has now become month to month, is it considered a month to month lease or is it a fixed term? I think this goes to the City of San Diego ordinance, possibly because the way that they talk about. I'm reading into the question because basic answer to your question is once the fixed term of the lease expires, it is a month to month lease. It's what we consider a month to month lease. The City of San Diego has this interesting 3-month timeline where a tenancy for 3 months is not subject to the tenant protections. And so then the question becomes, well, is a tenancy for 3 months a fixed term? Do you have to do a fixed term, or is it for any tenant who has been there 3 months or less? And I took a deep dive into that issue. I don't have my notes in front of me, but it depends on the intention behind the lease and how much rent the tenant pays up front. So a month-to-month tenancy, in my opinion, is a month-to-month tenancy, but depending on how you treat the tenant when the fixed term expired, if you treat them as a holdover or as a tenant that is unlawfully detaining the property, that can change their status, whether it's a tenancy at will or a tenancy at sufferance. These are the very technical legal terms that we start trying to interpret.
Yeah,
And
it's a holdover, right? It's a, you purchase the property, there's already tenants in there. If I remember last time's webinar, you mentioned that a fixed term lease has all kinds of tenant protection, but if you write it as month to month, then those protections magically disappear. So the question is really, as a new owner of a property with legacy leases that used to be fixed term but have rolled into month to month, do I inherit the legacy? Are they fixed term as far as I'm concerned on tenant rights, or are they month to month as far as tenant rights?
So it would be better to have a private conversation on this to make sure I know all the details. But if you buy a property with month-to-month tenants and you accept monthly rent, then it would be a month-to-month tenancy. A holdover tenant is, under most leases, still a tenancy at will, because most leases state, especially the California Association of Realtors form, that if the tenant holds over, and then all of the terms of the fixed term lease carry through to the lease, but it just converts to month. And so that's still at will. A tenant at sufferance is a different thing. So it really requires a case-by-case analysis of it, especially if you're trying to put it in the context of the City of San Diego regulation, because the way they wrote it is really confusing and has not been tested, to my knowledge, in the court. So you'd want to consider that under the circumstances of whatever is raising your question. So feel free to reach out and we can have a private conversation about that. All right, next question. How do you suggest serving the tenant protection ordinance guide and notice of exemption or non-exemption on the tenants? You emailed it to them, but the tenants mostly refused to sign or acknowledge, and we also mailed it to each tenant. Are we good, or do you need to do more? That's a good question. I think that it is stated in the ordinance that it would have to be served as in the same way that hold on, let me look it up because I have it around here somewhere. Sorry, now I'm blurry. Let me fix that quick. All right. They do not have to sign or acknowledge it, first of all. At this point, up to according to the law, up to September 23rd, all you had to do was serve it on them. But service, to me, let's see, email is oftentimes a good way of sending a notice, but not the kind that are required to be served to tenants under the law. So notice to tenant. Bear with me here for a second. I believe that first class mail at least is required, but I can confirm it right here. So it says written notice. Yeah, the only requirement on here is written notice. I recommend sending it by mail because I think that email, has the easy excuse that, hey, it must have gone to my spam. So if they acknowledge that they received it in an email, I think that would be sufficient. But if you just email it and you don't get any response, or if you have no proof that it was actually received, then I like to have proof, and so that usually requires at least certified mail. When I send certified mail, I also send it first class mail, because if they don't sign for the certified mail, they've got the first class mail that hopefully they open. Certified mail by law is deemed received upon mailing, as long as your address is correct, and even if they don't sign for it. But when I do it, I cover all the bases. But as I mentioned, the tenant protection ordinance only says that they have to be given written notice. So I would give it to them in such a way that you can prove that they received it. Okay. So next question, is a contract between homeowner and property manager enforceable? After a year, you decided that your property manager wasn't needed. Property management agreements and listing agreements are service-based agreements. Under California law, they can be terminated even during the term. However, the person who you held the contract with may suffer damages and may pursue any losses resulting from the termination of the contract. That means is, for instance, with a property management agreement, if they did find your tenant, they would be entitled, under most circumstances, if they found you a tenant at the price that you were asking and it was a qualified tenant, then that property manager would be entitled to a commission. Similar with a listing agreement, that if they bring in a full priced offer, they'd be entitled to a commission. And so there are lots of disputes that arise if a listing agreement or property management agreement is terminated before the term expires, and those disputes can also involve any amounts that the property manager or the realtor, real estate professional incurred expenses to stage the house or advertise it and that sort of thing. And it all comes down to the terms of the contract. But a service-based contract can be terminated if you just don't like the person or you're not agreeing with how they're doing it. There may be damages incurred, and so you may be sued for those damages for terminating it early. Does notice of rights and tenant protection guide only apply to the city of San Diego, or does it apply to the county too? It's only the city of San Diego. The county does not have any such ordinance, at least not yet. And to my knowledge, and by the way, I look this up every time the question is asked, but to my current knowledge, none of the other cities in the county of San Diego have any such tenant protection ordinance. Please let me know if I'm wrong, because I'm trying to keep up here. Okay, if an Airbnb guest stays for more than 30 days, do they automatically have tenant rights? I've seen Airbnbs go very badly, and yeah, once they're there for, I believe it's 28 days, and this comes down to the revenue and tax code and the way that the relationship is defined. They receive the rights of tenants if they stay beyond 28 days. We like to say 30 because that's where the city of San Diego has its cutoff for short-term versus long-term rentals. Can you get around that? I've seen people get around that. I've seen people able to enforce a short-term rental as a short-term rental even after 30 days. I'm not exactly sure how they did it, but if you came to me and this person had been there for more than 30 days, I would treat them as a full-blown tenant. There are different rules that apply to, what's the term that I'm missing? It's like a hotel. So, transient occupancy. And those are less than 28 days. And there are special rules that you can get the sheriff to enforce and remove the person. If you can show the sheriff that they are a transient occupant, then there is a kind of a restraining order type of procedure that you can go through to have them removed. All right, so to ask for more time, even the landlord doesn't want to give them more time. Oh, that's the 60-day. That must be Adriana going back to that 60-day question that you asked. So they have an option to ask for more time. Once the notice expires, talk to an attorney. But once the notice expires, the tenancy is terminated. Okay, and so once the tenancy is terminated, the tenant is unlawfully detaining the property, and that gives you the right to file an unlawful detainer. this depends, your right to file the unlawful detainer and succeed in the eviction depends on whether your notice was perfect. You know, the notice has to be perfect in order to have the right to remove the tenant. Depends on whether anything has happened in the meantime during the notice period that might have waived the notice, or, you know, change the notice in some way, or change the landlord-tenant relationship. So landlord always has an option to waive the notice and not file the eviction, but the tenant doesn't necessarily have that option on their own. But a tenant may defend themselves against their eviction if they feel like if they can prove that the notice was incorrect, defective, waived, any of those things.
Thank you.
You're welcome. And if the Airbnb guest stays for 29 days with a break for a few days and then returns for an additional period of less than 30 days, does that affect their rights? This is for County of San Diego. I mean, that gets into more of a case-by-case basis. It is very illegal for the places like SROs and places that, you know, where homeless people can find shelter, those kind of shelters that let people in for temporarily. It's not illegal for them. Let me finish that thought. That came out all wrong. So shelters, at one point there was a case, and there have been cases where the shelter was making people leave at 28 days and then letting them come back, and just having them shuffle through like that over and over again. And that was determined to be illegal, to let someone stay for 28 days and then send them out as though they've moved out and then let them move right back in. What you're suggesting is more of a voluntary relationship, maybe to get around certain regulations, probably illegal under the same terms that I was just saying, that if you are simply making the tenant move out and then letting them move back in just to avoid them taking on the rights of a tenant, the tenant could enforce the law against you. And I think that there could be some repercussions for that if the tenant chooses to do that. Would the repeal of Costa-Hawkins take effect on November 5th or at a future date if the repeal is successful? I'd have to review the legislation. So it's on the ballot for November 5th. When we all vote in 2024, November 5th must be election day. And so if it passes, then it would probably take effect January 1st of 2025. But I'd have to look more carefully at it to see. Adriana, I think it would be great to do a call. So if this is an issue you want to talk to me directly about, I'd be happy to.
No. Actually, you answered my question before. This was kind of explaining better, but yes, you completely answered the question. Yeah.
Okay, good.
Thank you.
Absolutely. You're very welcome. And I think I'm getting to the end of the questions. I'll keep going until 1 o'clock. And then if we have leftover questions, I'll try to reach out to each of you individually. So I've got a few more here. So one of the owners wants to start having a tenant pay for water. Is that considered a rent increase? Yes. It especially if the property is subject to the rent cap and just cause law. If it's exempt, then you've got a little more flexibility there. But when you calculate the rent for the purposes of rent cap, any increases in utilities or other expenses that are part of the tenancy are included in that calculation.
So Shanna, if I could, so then, because water is so uncontrollable, perhaps they might be better to just do, it is in the city of San Diego, but it is exempt. So they could possibly this year do a 10% increase.
So and that's the difference between giving them a 30-day notice versus a 90-day notice, since they're exempt, right? Is that specific what your issue is?
And
Um,
we would be definitely giving them 90 days notice, so.
Okay, as long as 90 days notice is being given and the property is exempt, then you can do the increase that you need to do, including the utilities. I'm sure you're aware, Jan, because I know you're familiar with leases, that especially the car form lease includes utilities as rent. So it's all wrapped up together.
Right. Yeah, yes, I just thought because it's so variable, it's like, I don't know.
Yeah.
But if they, I mean, it's so hard because if they just say, okay, yeah, that's fine, because if we haven't increased the rent ever, it's just, maybe they should just do a 10% rent increase and then try another increase in a year or something.
Well, I mean, it also depends on how your lease is working. So it sounds like the tenant is not paying the water directly to the water company.
Correct.
And
the water
so
was included.
Wrapped up with the rent, and
Yes.
yeah, that calculation needs to take that into consideration. But again, if it's exempt and you're giving 90 days notice, then I would say do what you need to do.
Okay. All right. Thank you.
Unless you're worried about losing the tenant.
They're not. So they've been there 3 years and and we've never raised rent. So.
Well, and let me know if there are details that you're not sharing, if you want to have a private conversation about that too.
Okay.
I understand there can sometimes be complications.
Thanks, Gina.
Sure. So, complicated multi-part question. May we still use a 3-day notice to pay or quit? Or do you now need 2 separate notices, a 3-day to cure the breach or pay and 3-day to quit? The answer is, if you're within the city of San Diego, yes. If you're outside the city of San Diego, it depends on where you're located. Now, the Tenant Protection Act, the statewide act, originally had language about using 2 separate notices, but that was amended and taken out. The city of San Diego regulation does have this 2-part notice requirement. Okay, next part of this complicated question. Do those notices have to be sent by a first-class mail, or can they be sent by a certified mail? The answer is neither. Well, notices to terminate tenancy you must attempt personal service. If you attempt personal service, it's not like a lawsuit. So attempting personal service for a tenant notice, you only need to do once. To attempt personal service, and if you don't find the tenant there, you can post it on the door and then mail it first class. You do not have to do certified. The only time you have to mail it first class is if you have posted it on the door. Now, when my guy posts notices, we make sure that he always does a first class mailing to all other occupants or all unknown occupants, because we don't necessarily know exactly who's in there. And just because you have personally served one person at the property does not necessarily mean that that person is going to give a copy of that notice to everyone else. Sometimes they'll just throw it away, or you don't know what they're going to do with it. So it's always a good idea to also mail it, even if you do succeed in personally serving it at the property. And if you know that there are 3 or 4 named occupants, it's recommended to mail it to each individual separately, just to make sure that they've all gotten their copy. Is that required by law? No. Is it recommended? Yeah, it is. Oh, okay, there's more to this question. Can we send those as owner managers, or are those best issued by an attorney? It's a preference of yours. Whatever your preference is, if you some clients prefer to have an attorney sign the notice because then it's scarier to the tenant and they know you mean business. Property managers can also sign notices as long as they are actually your property manager under contract, because the next thing that I'll ask for if you have to evict that tenant is, does this property manager have authority? Can you prove that they have authority to act on your behalf? Did the tenants know that the property manager had authority? If the notice is signed by somebody who the tenants don't know and doesn't sign as an attorney, then the tenants might say, well, we don't even know this person. Is this even valid? So having the landlord sign it, or whoever signed the lease with the tenant, is usually the recommendation, unless they're signing as attorney for the landlord. Does that mean Appfolio transaction fee constitutes a rent increase? I don't know. I think, aren't fees for property management fees, aren't those usually taken out of the landlord's proceeds? I don't know. I mean, I guess it depends on
I don't know
what
if you
you
can hear.
said.
There was an unexpected, at least unexpected to us, Appfolio transaction fee automatically applied to across our portfolio, and we had some understandably upset tenants. But what, in light of your answer about adding water fees, would that mean that this Appfolio transaction fee that was kind of applied across, I think, Appfolio unexpectedly, would that constitute a rent increase?
First of all, your lease has to give you permission to charge that back to the tenant, which most leases would. And then if it is part of your lease and the lease states that all of these additional fees and utilities are rents, are defined as rent, or usually what it is that rent is defined as any fees and expenses that arise from the tenancy, then yes, it is included as rent. And I think the cautious advice is to say yes, that it is included as rent. Could you debate that? Yeah, you probably can, depending on what the lease says. I know that's not much of a helpful answer, but I would be cautious and say that yes, it is included as the rent, and as long as your lease authorizes you to charge that back to the tenant, that it would be part of the rent. I think there's a statutory disclosure about water calculation that has to be given before the lease is signed. I believe that applies when there is an arrangement in a multi-unit property where there are different scenarios for how water is charged. And so we have issues with, apartment buildings where there is sometimes a separate company that's not the utility company, so the tenants can't hold the account themselves, and they get charged. So there's a disclosure that has to happen for those arrangements. There's also arrangements when a unit is not separately metered for utilities, and so then the lease has to state what percentage of the total utilities gets charged back to the tenant. So they would be entitled to a copy of the bill that's getting divided, and they would know what their percentage is, and they can understand that they're being charged the right amount. You're not allowed to profit from charging tenants for utilities. Hopefully that answers your question. Going back to the Airbnb question, you're specifically a transient occupancy business, a location with multiple vacation rental cabins. So if the guest stays for less than 28 days and then returns after a few days for another 21 days, is there any exception to tenant rights since you're designed as a transient occupancy business? Rather than giving you a direct answer to that question, it's hard to give you a yes or no. But what it comes down to is whether the sheriff will help you remove the tenant if the tenant refuses to leave. California law does not allow you to resort to self-help. So you can't physically remove an occupant from the premises. That's self-help. So what you need is some sort of authority by which the sheriff will come and remove them. And so I'm not the one who gets to decide whether you're transient occupancy status or not. It really doesn't come down to me. Is the judge going to give you a writ? Is the judge going to give you an order? that you can then take to the sheriff and get them to remove the person. There are other ways of taking possession, but if that person is in the premises, you can't physically remove them. You have to actually get the sheriff to do it for you. Yeah, okay, Stephanie, you've given me the civil code for water. Okay. And do you need to personally serve 3-day notices? You have to attempt personal service. You have to make a diligent attempt to personally serve a 3-day notice. If you can't find the tenant or someone over the age of 18 at the premises, then you can post and mail it. Convenience fee. I think I answered your convenience fee question. All right, that's everybody. So thank you all so much. I'm so pleased to be able to present to all of you, and thank you for coming today. And please feel free to give us a 5-star Google review if you feel like it. And I'd appreciate it very much. And I just will see you next month, I guess. Thank you.